All right, if you're gearing up for the LSO paralegal licensing exam, then you are in exactly the right place. We're about to break down two really important chapters, 9 and 10, all about managing the client relationship. And listen, this isn't just some boring theory. These are the rules that pop up again and again in those tricky exam questions. So let's just dive right in.
So, let's start with a big question. When it comes to your clients, what's the single most important skill the Law Society wants you to have? It's not just about being a legal genius. It's about something more fundamental.
And there it is, managing expectations. From that very first phone call all the way to the end of the case. Your ability to communicate clearly and guide the client through the process is absolutely critical. And you can bet that on the exam, any failure to do this is going to be a major red flag for professional misconduct.
So here's our game plan. We're going to start with the big picture, the client life cycle. Then we'll zoom in on starting, managing, and importantly, ending the retainer. We'll spend some real time on the withdrawal rules because they're tricky. And then we'll finish up by flagging the most common traps the exam will throw at you.
Okay, first up, the life cycle. I want you to think of this as your mental map. Seriously, every single scenario question on your exam that involves a client, it fits somewhere on this map. If you know what stage you're in, you'll know exactly which rules apply.
So every single client relationship has these 4 distinct stages. First, you've got the initial screening. This is where you're figuring out if you can even help this person. Then you move to engagement, or non-engagement, where you make it official. Stage 3 is implementation. That's the guts of it, doing the actual legal work. And finally, disengagement, which is all about closing that file properly.
Now let's focus on stage 2, starting the retainer. This part is so important because it's where you lay the entire foundation for the relationship. And you guessed it, the exam loves to test you on the paperwork you need to get right at this stage.
Okay, let's really break this down because this is a huge deal on the exam. You've got 2 critical letters here. The engagement letter, that's the easy one, right? It's your official, you're hired letter, spelling out the scope, the fees, the whole deal. But the non-engagement letter, this is where people get tripped up. It's just as vital. If you talk to someone, even for a few minutes, and you don't take their case, you must send this letter. And the exam will 100% test you on what goes in it. You have to clearly state, I am not your paralegal, you have to return their documents, and this is the absolute kicker, you have to warn them about any upcoming deadlines or limitation periods. That last part is a biggie.
All right, so once the retainer is signed, you're in the thick of it, the implementation stage. This is all about the day-to-day work, which means ongoing duties of competence, good service, and really clear communication. It's also where you might start to realize, this client is a little bit challenging. So picture this on your exam. The question tells you about a new client who's already burned through 2 lawyers and another paralegal before they got to you. What should immediately pop into your head? What is that a trigger for?
It's a massive trigger for a potentially challenging client. This slide lists the exact red flags the LSO expects you to see from a mile away. Now, the exam isn't saying you can't represent these people. What it is saying is that you'd better recognize the risk and manage it with super clear, documented, confirmed in writing communication every step of the way.
Here's another absolute classic exam scenario. You're working on a file and something pops up that is way outside your wheelhouse. You've never seen it before. What does your professional duty require you to do? You have exactly 3 choices. You need to know these cold. Number 1, you can just decline to do that part of the work. 2, you can get your clients okay to bring in someone who is competent. Or 3, you can get the client's permission to learn how to do it yourself, but only if it won't slow things down, create risk, or cost them extra money. Be really careful here. If you see an answer choice that says something like, just try your best, that is the wrong answer, every single time.
Okay, we're at the end of the line, ending the retainer. This is all about the rules of withdrawal. And here's the key thing to remember. A client can fire you whenever they want for whatever reason. But your ability to fire your client is very limited.
If you're going to memorize one thing from this section, make it this sentence. Seriously, this is the bedrock of everything. Every single rule about withdrawal flows from these 2 principles, good cause and reasonable notice. You have to have a real, legitimate reason, and you have to give the client enough warning so they can find someone else without their case getting torpedoed. Burn this into your brain.
So, that good cause we just talked about, it gets split into 2 buckets you absolutely have to know for the exam. Situations where you must withdraw and situations where you may withdraw. And trust me, telling the difference between these 2 is a favorite for exam writers.
Let's run through this. Mandatory withdrawal means you have no choice. If your client fires you, you're out.
If they tell you to lie in court, you must withdraw. Same goes if you realize you're just not competent to handle the file anymore. Now, optional withdrawal is different. This is for stuff like a client lying to you. That's a serious loss of confidence, or if they stop paying their bills. In those cases, you may be able to withdraw, but only, and this is a big only if, it won't cause serious harm to their case.
Now there's a huge exception you need to know, criminal cases. For these, timing is everything. Look, if the trial is months and months away, you can usually withdraw for non-payment, no problem. But if that trial is right around the corner, forget it. You are not allowed to withdraw for non-payment if it's going to mess up the client's case. For pretty much any other reason close to trial, you're going to need to get the judge's permission to get off the record. The closer the trial, the harder it is to leave.
All right, let's switch gears and do a rapid-fire round of the biggest exam traps. These are the tricky questions designed to make you second-guess yourself. We're going to make sure you don't fall for them.
Okay, first trap. Your client fires you. They still owe you money. Their new paralegal calls asking for the file. Can you hold it hostage until you get paid?
This is a classic, and the answer is almost always no. While you technically have a right to a lien on that file, it does not trump your duty to prevent harm to the client. If holding onto that file is going to prejudice their ongoing case, you have to hand it over. The client's interests come first, period.
Next one. A potential client calls. You chat about their case for maybe 15 minutes, and then they decide not to hire you. Is that the end of it? Are your obligations to them completely finished?
No way. It's a trap. Even from that short little chat, you have duties that stick around. You owe them a duty of confidentiality, forever. You have to add their name to your conflicts checking system. And, like we talked about, you still have to send that non-engagement letter, especially to warn them about any deadlines.
So, let's wrap this up. What are the absolute must-knows for exam day? First, get those 4 stages of the client relationship down pat. Second, document everything, everything in writing. Third, the withdrawal rule, good cause plus reasonable notice. Fourth, know the difference between mandatory and optional withdrawal like the back of your hand. And finally, the golden rule, your ultimate duty is to prevent any prejudice to your client.
I'll leave you with one final thought to chew on. You can memorize all these rules for the exam, and you should. But what's the one habit, the one practice that's going to protect you and serve your clients for your entire career? It's simple, consistent, clear, and documented communication. That's the thread that ties all of this together. Now study hard and go crush that exam.